Hello. Today we are talking about defamation from the strictly legal point of view, in the sense that we will analyze what legal rules apply when we speak of defamation. First of all, there is a Quebec Charter, which applies to private persons, people like you and me, as opposed to simply the government establishment and government organizations. So we're talking of Quebec Charter, and Quebec Charter gives us a right for freedom of expression. It's seen as fundamental right, of course, but at the same time a right for dignity, honor, and reputation. And as always, none of those rights is seen as absolute. So first yourself, and later, if ever you're in court for defamation, being a plaintiff or defendant, being an attacking person, claiming person, or the one in defense, the court will try to balance to see if this particular word and information and rumor, opinion, whatever spread, had this value of freedom of expression or not so much, and if it really touched dignity, honor, and reputation, or not so much. And if it's yes and yes, what was more important in this particular situation? Also, Quebec Charter gives protection to your private life, and this adds to this balance and exercise. So as much as their word, the information, damaging your reputation and dignity was also encroaching on your private life, it's closer to defamation. If it's more about public life, political issues, public order issues, particularly important to the society, then it's more about freedom of expression. Also, Quebec Charter speaks of unlawful interference. So if some publication about you was justified from the legal point of view, for example, was ordered by the court or by some legal authority, or simply was within particular rules, for example, your verdict in whatever decision was published, then by default it's not defamation. Civil Code of Quebec also speaks of reputation, of the damage to the reputation, but more importantly, Civil Code of Quebec gives mechanisms, like what do you do when your rights are violated, or you think that your rights were violated. Here you have the famous Article 1457, which gives you basically the right to sue. And also you have several articles which show what kind of compensation you can get, like damage of bodily nature, moral nature, and also punitive damages. And the code specifies like what is what, and how much can you rely on your own assessment. But to sum it up, you can read it here, of course. To sum it up, you have to prove. Like if you claim that damage was done, you have to prove that. You have to show invoices if you needed some medical assistance, even a psychologist or psychiatrist, because of stress and suffering. You could and should show that you actually lost some money because you couldn't work, or you lost your job because of that, or you were degraded in your position in some company, or you didn't get some promotion. But again, you'll have to show that otherwise you would get this promotion, and that this change was exactly because of this defamatory information, defamatory words, and so on and so on. But if you can do that, yes, you can claim damages. As opposed to, at least how do we usually perceive, justice system in the United States because of those TV shows and some publications. Moral damages, the idea of moral damages is not that strong, is not that infinite in Canada, in Quebec, as it is in the United States, probably. So normally you cannot claim that much. In a regular situation, it would be something like several $1,000s. Again, if you can show the real loss, and only if you can show that the actions of the other party was intentional, unlawful, in bad faith, then you can ask for punitive damages. And again, the judge would see the amount against the actual capacity of that person to pay, so that the amount would be not something as a compensation to you, but something as a punishment to that person. And for some person, $100 is a lot. For some people, $10,000 is not so much. So the judge, or for some organizations, the judge would see and would make this decision. Basically, to claim is not enough, and to think that you can claim millions is like not realistic in this situation. There is a thin point, like subtle point, I would say, about where the word was spread. Because in normal situation, according to the Civil Code of Quebec, you have 1 year since the moment when you were defamed, or at least since the moment you should have known that you were defamed, to bring an action if you want to, of course. But in order, again, to protect freedom of expression, it's different when it comes to newspapers and like sources of information like newspapers. There you have only 3 months, but what is a newspaper is defined in the Press Act and connected in like Newspaper Declaration Act, as you can see. And those acts were brought up well before social networks and like online spread of information. And as of now, at least, according to the decision of the Court of Appeal of Quebec, this limitation does not apply to online sources of information. The judges were sort of critical about the legislator who did not change the act, but anyways. So basically, if you were defamed, as you think at least, in a sort of like official source of news, like regularly published source of news, then the Press Act applies. But if it's just some news aggregator, some site, some web page, or if it's a Facebook, even if it's a channel or something like that, then at least for now, it's not covered by the Press Act. So it's not 3 months, it's 1 year. That's the like legal starting point for all of that. If you think again that your case falls within these limits, and if you still have time, 3 months or 1 year, then you can think of bringing up an action in defamation. But again, it might be a wrong decision. So before doing that, before spending money, it's a good idea to think. But if you think that it might be a case, then definitely it would be a good idea to see a lawyer and discuss your particular situation with a lawyer. Thank you. Have a nice day. Goodbye.